Okay, commission members, we return to motion for reconsideration, case 2021G-005. And we have a motion filed by the respondents for a reconsideration of the decision of the board. We have both counsel present in this case, and we have received a motion and a response. Again, commission members, we desire to proceed on the same lines as our last motion, which was for the benefit of Mr. O'Brien. We gave each party 10 minutes to give an oral argument, or less if you need it, but we have read the materials. The commission has looked through everything that has been submitted. We'll allow the complainant to reserve time if he so chooses, and then well, it's your motion, so you go first. Sorry.
Yes, and I certainly will need 10 minutes.
Thank you. Mr. O'Brien, if you would identify yourself for the record and
yes,
to the lectern so we can
thank you, Acting Chairman Ron O'Brien. For the record, High Supreme Court number 0017245. I did file a motion to reconsider on behalf of State Representative Gene Schmidt. The court, Commission will recollect there was a preliminary review on August 12th, and after the preliminary review, I was frankly unsure. I had raised questions on the lack of personal knowledge, I raised questions on the lack of probable cause, and I raised questions regarding the lack of a substantial factual dispute that needed a hearing. And as the Commission members will recollect, Mr. Richter had recommended that it be dismissed with the finding of no violation. There was a 3-3 vote with the Chairman Price recusing himself, and then a subsequent vote. Well, it wasn't dismissed on any of those reasons, and the Executive Director's recommendation was not followed. Let's set for hearing, and that passed 6-0. And at least I was left wondering, well, are we saying personal knowledge is not required? Because quite clearly, 2 affidavits didn't establish personal knowledge. Number 2, are we saying that there was a corporate contribution in trying to determine what I need to do to represent Ms. Schmidt? What's the corporation that made this contribution? The only one referred to, I think, was Constant Content, which is an LLC, and then secondly, there were issues where I had suggested that it made sense to try and narrow the issues, to look at each charge separately and whether or not there was probable cause on one but not on another. And so, in looking at the Commission rules that authorized a motion to reconsider before the order went out, and the order gets approved in minutes, and the minutes presumably are the last item on the agenda today that will be approved. So it's a timely motion to be considered, and trying to determine what should happen going forward. It seemed to me that the lack of personal knowledge was present, the lack of probable cause was present, and the lack of jurisdiction for that reason, and that we're really subjecting Representative Schmidt, depositions which Mr. Hicks has already made discovery requests, which I believed would not be operative until the Commission did act by approving the minutes that set for a hearing. And so I've not yet answered those, plus I was awaiting the decision on Mr. Bry's motion, which we just heard, because that implicates this case and some others. So at least I was just seeking clarification, and perhaps if Mr. Richter was instructed to include A, B, and C in the order that goes out, as opposed to just, this matter set for hearing on October 23rd or whatever date that Commission picks, then that would be sufficient for my purposes. But at least I'm kind of at a loss about what the Commission did and what you found. And if you found there was probable cause, to face the affidavit where that would exist, and I didn't see it existing there. And if you found a substantial factual dispute requiring hearing, that would exist on the face of that and the other information submitted to the Commission, which was the affidavit of the Executive Director of the Republican Party saying that Mr. Mancini, as alleged by Mr. Hicks, was not paid to for or directed to participate in Schmidt's campaign as a part of that compensation. So those are the reasons I filed the motion. Happy to answer any questions.
Any questions by commission members? Hearing none, Mr. O'Brien?
Okay, thank you. And that was probably about 4 minutes.
2 minutes and 30 minutes.
I have 4 minutes and 8 seconds, but we're up.
Yeah, I was a little slow in starting.
We appreciate the efficiency.
I might be less efficient, not because of I'm not trying, but because I got 2 lawyers here, me, Pro Se Chris, you know, looking through things quick, trying to collect my thoughts on what I wanted to hit on during these few minutes. This constant, I wanted to just hit on it. I'm going to flip around here. I might have made a few notes as he was talking, Sir Brian was talking. This notion of the constant use of personal knowledge by attorneys that make their living off this commission is, to me, borders on the ridiculous. So just, I'm going to read this or paraphrase out of my own filing in this matter. So where did my knowledge come from? Seeing Ms. Schmidt's ads as a resident of her district. Conversations with her constant contact paid advisor, Steve Caraway. Staking out and filming Luke Householder as he was working in Claremont County. Aiding her campaign and that of Alan Freeman. Identification of the venues that were pictured in materials by the campaign. Mapping of the money flow. Digging into Ms. Schmidt's finance reporting provided by the Secretary of State, and being a member of the Claremont County Central Committee and getting to hear Ms. Schmidt talk about her relationship with Larry Householder and her campaign all the time. So I asserted 3 things principally in my complaint. I know there was a smorgasbord of requests by Mr. O'Brien. You know, I asserted that R.J. Mancini provided services to the Schmidt campaign while being paid by the ORP and was not disclosed as an in-kind contribution. I think stuff we've already seen in 2020 G019 shows that the supervision, and if you go read the affidavit of Rob Secure, it's like, we did not specifically, the words are, we did not specifically tell R.J. Mancini to work with blah, 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 because they had ceded control of the ORP resources to Larry Householder people. Okay, so that's why that affidavit is worded in such an awkward way and should not be represented as some definitive statement. That's one of the things I asserted. And I think I have lots of evidence of that, that was from my personal knowledge and investigatory work. Steve Caraway, Tommy Rolfe, Luke Householder being paid for services provided to the Schmidt campaign were not disclosed in the campaign finance report. I personally talked to Steve Caraway about this multiple times. Okay, constant content, fronting 164K. He gets on the LLC because somewhere in my complaint that there's a possible violation of corporate contributions. I think that like the matter involving Alan Freeman, there was either an LLC as an individual, there was either a contribution made significantly in excess of the limit, or if you look at that as laundered money through First Energy and Generation Now, which is where the money came from, that's a corporate contribution. So that's something yet to be determined. But the origin of the money that got used to front into the campaign that was paid back later, what was the basis of that? So I think that the allegations that I had are all based on a significant amount of knowledge. And I brought up here before the commission, I think what your personal knowledge thing, you should put a bullet in the head of these arguments in terms of what you need to prevent is what I call straw filers. Like somebody makes something and I come in and file it to hide who's actually doing it. I've done all my work. I've had my own conversations with these people. But he keeps coming in and asserting that I don't have personal knowledge. Okay? He also asserted something in his brief about, you know, a statute didn't apply because she was not required to file the report when she did file the report, the semi-annual report. So these kind of arguments, again, we get into these never-ending procedural discussions here that never get at the facts of these cases. And I think it's really scary. On the other case, I'm still a little confused on what we decided. I never said that a person couldn't assert their Fifth Amendment right. The question that we should have been considering is, can you assert your Fifth Amendment right against your own affidavit? Can you be questioned, do you have to take the Fifth in person, and can you be questioned on your own affidavit? But on this particular matter, I just want to point out again, I think I learned a lot. Hopefully, my briefs that I sent to you are part me learning how this works and studying your rules. And I'm sure that none of you ever imagined when you got appointed to this, you'd be studying the rules as much as you are on these cases. But, you know, a preliminary review, I've made this mistake of saying preliminary hearing. There's nothing called a preliminary hearing in your rules. A preliminary review has two parts, a probable cause panel, which I don't know that you ever use, and the full commission. And in the full commission part, the word probable cause is never in there. And it says that the full commission can set a matter for hearing by the full commission if it finds there's a significant factual dispute exists or there is uncertainty as to the material fact necessary to determine whether there is a violation to any or all of the allegations. So I think that your prior unanimous decision, based on, you know, a significant amount of personal knowledge and evidence that I've put together related to this, was the right decision to just go to the next level and let it play out as to what actually happened, what happened with this money. But I think these things are compelling that I put forward. And the question is, that, you know, I think this is, again, I keep saying, canary in a coal mine situation. There's bigger cases coming, right? There's all those little Rose referrals. There's all of this, all of that are coming before you. These are canary in the coal mine cases in terms of basically what Mr. O'Brien is challenging is, do you as a commission have the right to say we want a full hearing for more information? And that's why I think you absolutely have that right. I think it's very important. I think your rules need to get cleaned up. If you've noticed from some of my briefs, there's places where the titles of the rules don't match the language in the actual rule, right? The words in the title don't appear in the actual rules. It's in the case here on a preliminary review. But for, you know, in my brief, for all the reasons that I brought up, I think your decision was correct before. Mr. O'Brien, I sent a discovery request to Ms. Schmidt, and I sent a discovery request to her treasurer, okay, which he has ignored. He ignored for 3 weeks, and then I reminded him to, if you read my brief, I reminded him you should file something, you know, not just let this play out. But we missed another hearing. You guys canceled the hearing. I think you made the right decision. I think everything I've done is based on personal knowledge, including conversations with people that were involved with her campaign that I could testify to. And this absolutely begs for more information and for a full hearing. I think there's absolute probable cause of what's involved, but I'm not even sure that's necessary for you to ask for a full hearing. I think you can ask for a full hearing just because you want a full hearing. You want to hear more information on something so that you can make an informed decision on what to do with it going forward. And I apologize, I know these cases are probably hard, and you'd rather, I know if I were in your position, I'd rather have cases on signed disclosures and stuff like that, like straightforward stuff. But these are the cases that are really important for the future of our state and for clean finance reporting and for integrity of the process, and that political candidates realize they have to respect the process. So thank you for the time.
Thank you. Mr. O'Brien. Oh, wait. Any questions by commission members? Hearing none. Mr. O'Brien.
Yeah, very briefly, Mr. Hicks wants to attribute personal knowledge to something that isn't personal knowledge. And if he does have that personal knowledge, it's not in his affidavit. He just said, let me testify at a hearing to illuminate the issue. The issue has not been illuminated in his complaint. You have to look at the complaint and on the face of the complaint and the affidavit and any other information, make a determination, is there a significant factual dispute requiring a hearing, or is there probable cause? And he says, well, look, Luke Householder was in Claremont County. I took his picture. So what? That does not prove, and it does not prove personal knowledge that he was there to work on Gene Schmidt's campaign. And he doesn't allege that he saw him work on Gene Schmidt's campaign. He doesn't allege, I saw me and see hanging signs, passing out literature. I mean, he says they're there, but that proves nothing. It does not establish probable cause, and I guess that's my concern, and at least he or anyone else, and I know some of the members of this commission have run for office themselves. You can file an affidavit making an allegation and say, let me go on a fishing expedition, and that's what he's asked you to do. And I guess that's been my concern, and that's why I asked for the reconsideration. Nothing further. Thank you.
Thank you. Questions by commission members?
I do have a question.
Yes.
I can tell you what I think personal knowledge in like real world situations mean, but what does it actually mean regarding being able to bring something to us that we will, like in, I guess, legalese, if that makes sense, what does that really look like? Because I want to make sure that I'm not looking at it through the wrong lens.
Mr. Richter?
Well, how I have always approached moving matters before the commission is reading the complaint and seeing what is contained in there. In this particular instance, Mr. O'Brien, you know, there isn't the phrase "on my personal knowledge" in the affidavit. And in a lot of affidavits that the commission receives, that's not the case when they come from pro se persons. It isn't included in there. If it should be, I'll take direction from you guys to say, make sure that's there in the future, and if not, reject. But I've always looked at the entirety of the materials provided, and in assessing all of those materials, then make the decision to set the matter forward. And in addition, you know, honestly, from a real basic process of sending matters before the commission, I look at very basic information. Is there a name and address for complainant, respondent? Is there a statement of the case? Is it properly notarized? That says this is a sworn statement signed and sworn before the notary public. Is it originally signed? And if so, I put it before you. But I look at then the body of the complaint and see what's all in there. And, you know, as I read Mr. Hicks's materials that he submitted in terms of reviewing campaign finance reports, assessing those, getting that kind of information, and subsequently putting it out there. You know, you could certainly argue that maybe some of the other stuff isn't, but also just looking at the general circumstances in every complaint, and if there isn't, you know, as I look at things, a reasonable assessment that what has been done to bring that complaint before the commission, and is it sufficient, I'll move it before the commission. I don't know that the commission doesn't have a specific rule that says this must be included in order to make it an affidavit of complaint. Well, it does, we do have that in terms of making an affidavit of complaint. It has to be properly notarized and sworn properly. That's the element of it. But other than that, when I bring something before the commission, I look at all of the circumstances that are laid out in the complaint. Mr. Hicks made reference to a disclaimer complaint. Have they made the assertion that it's not there? Have they looked at the material? You know, it helps if they send in a picture or something along those lines so we can actually see it. But you know, that's sufficient for me, even if the words, you know, I base this on my personal knowledge, are not specifically included in the materials.
And what's your process if it wasn't sworn, or there's no notary, or there's not the substance of an allegation?
If there's no notary, or if there's an improper notary anymore, it gets sent back immediately. If there is a notarization on it and it's signed, but you can tell, you know, it's like, I read the newspaper article, and the newspaper article said this. Well, that's not real personal knowledge of the facts and circumstances of any particular matter. That's reading secondhand, more or less secondhand material. I would probably put that before the commission, but then as a part of my recommendation to you, I would probably recommend that the commission dismiss it for failure to properly invoke personal knowledge. I haven't done that very often, but I've done it before when a complaint comes in. Because like I said, the first thing I do is look at 5 basic elements, and if those are there, it goes forward before I interject myself into the situation. And if there's not sufficient, in my opinion, a sufficient showing, then I'll recommend dismissal. You guys will all have still an opportunity to review that if the person comes before you, has other comments that they may have, and they may, you know, whatever else, if they come in person and appear, or you can assess it for yourselves and see. Because I'm certainly a recommender, I've always said that, I'm a recommender, you guys are the deciders. And so that's the process that I use as I go forward. Hope that helps.
And in this case,
Process procedure is that we don't want to have these thrown out because of a technicality or procedural following. Let's get to the merits of these things.
so, and in this case, what was your process, Mr. Richter? Case before us here.
I don't have his complaint right in front of me right at the moment, but certainly some of the elements that he just cited as he was standing up there go into my assessment of his complaint. That he looked at campaign finance reports, that he assessed those campaign finance reports, he witnessed those things and saw those, and brought them forth to us. I can't remember some of the other things that he referred to, in line with what Mr. O'Brien has said. Yeah, he saw a blue householder there. Is that sufficient? That probably isn't sufficient, but that's something that may come out if it decides to go to a full hearing, as you guys have decided, whether he actually did work on something like that. That's one of those, to me at least, that's a marginal issue that, as I'm assessing the written complaint, if there's more to it than that, that's certainly something that I will say, okay, that's fine. You'll notice I didn't recommend dismissal in an early stage in this, because I feel like some of the efforts that Mr. Hicks undertook to move this thing forward were sufficient to establish that he has personal knowledge of this facts and circumstances.
Any other questions by commission members? Discussion.
So, the issue before this commission right now is whether or not to grant respondent's motion to reconsider. Is that correct?
Correct.
And the question is reconsider what in our, I think from my perspective, it's reconsider what. And that would be our decision. We did not grant the motion to dismiss. So the motion to dismiss was not granted and the matter was set for full hearing.
Correct.
So I anticipate that the reconsideration would be whether or not we're going to reconsider that decision and do something else. Mr. O'Brien is requesting that the reconsideration, that we actually consider, various claims and dismiss individual claims potentially to parse it out or not. I don't know that we, under our rules and I will look to Mr. Rick on this, under our rules or otherwise are required to do that. Certainly you could, but I don't think we're required to do so. Mr. Richter?
No, at least at this stage of the proceedings, I'd say no. Certainly, I appreciate that it may cause great distress to Mr. O'Brien, but to me, the commission made its determination as to how it wants to proceed. It wanted to go to this thing to set it for a full hearing, and so I believe that should be the case, and it should be. And certainly, if the commission decided it wanted to limit some of the elements of it as he had requested in his motion, you could certainly do that. My recommendation would be to deny reconsideration. I don't see this case as being one where I want to see the commission potentially look at getting regular reconsideration motions after they decide to set a hearing. It's not a final order, it's not a final determination. You certainly could have said, yeah, we're going to, I'm trying to think of which case it was that, sorry, Mr. Bryan, bringing you into this one because it was your client, where we had a hearing. You didn't end up representing him at the hearing. I can't remember the gentleman's name right at the moment, but we made a decision on a couple of issues and then set the rest of them for hearing. We have separated before and said, okay, we're not going to hear this. When we would deal with probable cause panel issues, when we were dealing with false statement cases, there were various times when we would say, okay, we're not going to hear this, we're not going to hear this, we are going to hear that. You could have separated it out. Would it have been better? Okay, maybe it would have. May have been a little clearer, but the determination was to set the matter for hearing. So to me, that's the commission's decision. That's where we are at this point. I believe the matter should go forward.
And that is not a merits decision, that's a procedural decision.
Correct. It's not. We have not made any determination. The commission may find that there's no violation in any of those allegations. May find that there's one or two violations. Now when we get down to that level, and I think most recently everybody experienced it in the Trevor Elkins case, when you have contentious issues, I guess I'll phrase it that way. We have broken out those issues and said, okay, we're going to find a violation here, we're not going to find a violation there, and we've separated things out. And that's something too that we historically, I always go back to the case that was appealed by the commission, and the commission made a basic finding of violation of false statements, and it was appealed. And now I'm not remembering the judge's decision when it was sent up to him on appeal, but there were probably about 8 false statements included, and I think it was before you were on the commission the first time. And the judge went through and said, nope, that's not false, nope, that's not false, nope, that's not false. But he had identified each element and then came to the last one and said, yeah, that is false. And so I'm gonna uphold the commission's determination. And I felt like from that, I learned, because it was when I was still, this was going back 20 years, I learned if you get into a situation where you have multiple issues, let's break them out and make determinations on each one so that, if we make a finding against Mr. O'Brien's client down the line, we can find no violation here, no violation here, but yes, there's a violation here, and if he wants to appeal, we've identified that item in which we have made a specific finding against his client so that it's not throw something against the wall and hope it sticks kind of circumstance.
Any further discussion, questions by commission members, question for Mr. Hicks or Mr. O'Brien?
We were unanimous in our conviction to set this very hearing last time. I move that we deny the motion for reconsideration.
Was that
Yes.
We got a motion by Mr. Norman to deny the motion for reconsideration, second by Commissioner Tavares. Any further discussion? Roll call vote.
Mr. Brewer,
Yes.
Ms. Kaufman,
Yes.
Mr. Norman,
Yes.
Ms. Tavares,
Yes.
Chair Cunningham,
Yes.
or currently sitting Chair Cunningham. That motion passes 5-0.
Thank you to both.
Thank you for your
parties.
consideration.
Thank you for your time and succinct arguments.
I'll get Mike first.